Welcome to another deep dive. Today, we're going to be tackling legal systems.
Sound like fun.
Yes, which is business law. Introduction to the Nigerian legal system.
Okay.
Now, I know what you're thinking. You're thinking, I'm never going to Nigeria. Why do I need to know about their legal system?
Right.
But I actually think that this is really relevant for anyone, anywhere. Because understanding how legal systems work it's kind of like understanding the rules of the game.
Yeah.
You know, whether you're in business, negotiating a contract, or just trying to understand how society functions.
Exactly. Yeah. It's about recognizing that laws aren't just these arbitrary things. They
Right.
reflect the values and priorities of a society.
Absolutely. Okay, well, let's dive into this source. It starts by talking about the definition of law itself, which you might think would be pretty straightforward.
Yeah.
But it turns out there's a lot of debate about this.
Okay.
So it starts with this very classic view of law as a command of the sovereign backed up by sanctions. So basically, the king says something, and if you don't do it, you get punished.
Right. Like the old school view of law.
Yeah, exactly.
Yeah.
And then it talks about how this view evolved over time to see law as a set of rules
Right.
that are designed for the common good.
Yeah.
So not just about punishing people who break the rules, but about creating a system that benefits everyone.
That's interesting. So it's like a shift from law as a tool of control to law as a tool for social harmony.
Exactly.
Hmm.
And I think both of those views are kind of at play in modern legal systems. You know, we have laws that are designed to punish wrongdoing, but we also have laws that are designed to promote things like public health or education.
Right. It's like a balance between maintaining order and promoting well-being.
Absolutely.
Yeah.
Okay, so we've got these different ways of looking at what law is, but then the source takes us into the specifics of the Nigerian legal system itself, and it outlines the different types of law that they have.
Okay.
So they have public law, which governs the relationship between individuals and the state, things like constitutional law or criminal law.
Right.
And then they have private law, which governs the relationships between individuals, things like contract law or property law.
Yeah.
So it's like this map of the legal landscape, showing you all the different areas where law operates.
Yeah, it's helpful to have that big picture view, right?
Absolutely. And then the source goes even deeper and explores the sources of Nigerian law. And it turns out it's not just one thing. It's this really fascinating mix of influences.
Oh, okay. Like what?
So they have acts of parliament, which are laws that are passed by the Nigerian legislature.
Okay.
They also have English common law, which is this body of legal precedent that's been developed over centuries in England.
Right.
And then they also have customary law, which are these traditional legal practices that have been passed down through generations.
Wow. So it's like a legal tapestry woven from all these different threads.
Yeah, exactly. And I think that's true of a lot of legal systems around the world.
Right. They're not created in a vacuum.
Right. They reflect the history and the culture of the societies that they're a part of.
Yeah.
Okay. So it's not just about the laws themselves. It's about how those laws are created and how they're interpreted. And speaking of interpretation, the source gets into the nitty-gritty of how judges in Nigeria actually make sense of the law.
Okay.
And they have these different rules of interpretation, which I always find fascinating.
Okay.
So one of the rules is called the literal rule, which basically means that you interpret the law exactly as it's written. You don't try to read between the lines or anything like that.
Okay. So you're taking the words at face value.
Exactly.
Yeah.
And then there's the golden rule, which says that if a literal interpretation of a law would lead to an absurd or unjust outcome,
Right.
then you could deviate from the literal meaning to avoid that outcome.
That makes sense. So it's like a safety valve to prevent the law from being applied too rigidly.
Exactly. And then there's the mischief rule, which is my favorite.
Okay.
And the mischief rule says that you should interpret the law in a way that addresses the mischief or the wrong that the law was designed to address.
So you're looking at the intent behind the law, not just the letter of the law.
Exactly. So it's almost like a detective game, right?
Okay.
Judges have to figure out what the legislature was trying to achieve with this law and then apply it in a way that makes sense.
That's a cool way to think about it. It's like legal sleuthing.
Yeah, exactly. And the source gives us some really great examples to illustrate these rules. So one of the examples is this thing called the ambulance parking conundrum.
Okay.
So imagine there's a law that says no parking on the road.
Okay.
Okay, pretty straightforward. Now imagine an ambulance comes screaming down the road and needs to park to respond to an emergency.
Right.
Well, under a strict literal interpretation of that law, the ambulance wouldn't be able to park there because it's on the road.
Right. Which doesn't make any sense.
Right, exactly. It would be completely absurd and unjust.
Yeah.
So in that case, a judge would probably apply the golden rule and say, Okay, the intent of this law was not to prevent ambulances from parking during emergencies. The intent was to prevent people from parking their cars there.
Right, to keep the road clear.
Exactly. So it's not just about blindly following the words, it's about understanding the intent behind them.
I see. Yeah, that makes a lot of sense.
Yeah, and that's why the mischief rule is so important.
It's like you have to be a mind reader in a way.
Right. You have to
Yeah.
figure out what the legislature was thinking.
Exactly, yeah.
Okay, so I think all of this just goes to show that there's a lot more to law than just the words on the page. There's this whole process of interpretation and application.
Right.
That's really fascinating.
Absolutely. It's a very human process.
Yeah. Okay, well, we've covered a lot of ground here. Practical workings of a legal system. But I'm really curious to see how this all ties together.
Me too. I have a feeling we're going to uncover some interesting connections.
Absolutely. All right, well, let's take a quick break and we'll come back and talk about all that.
Sounds good.
All right, let's dive into Nigerian business law. You're prepping for a big course on this, right?
Yeah, a bit nervous, to be honest.
Well, you've got a ton of materials here. Looks intense.
Modules, excerpts, even a whole section on something called the Sale of Goods Act.
Oh, wow. Well, consider this your crash course before the real deal. We'll break it all down, highlight the key stuff, and get you feeling super confident about that course.
Sounds great. Where do we even begin?
Well, you can't talk business law without talking, law in general, right?
True.
What exactly is law?
So the materials define law as, well, basically rules and regulations.
Okay, sure.
But the important thing is they're backed by authority. Like, they're enforceable. You break them, there are consequences.
Right. It's not like your friend asking you to do something. It's more like...
Yeah, it's got real weight behind it.
Exactly. And speaking of different kinds of rules, the materials mention how Nigerian law is categorized.
Yeah.
There's public law, private law, even international law, right?
Yep. Public law is all about the state, how it interacts with individuals.
Okay. Like criminal law, for instance. Someone commits a crime that affects everyone, the state steps in.
Gotcha. So what about private law?
Private law is more about individuals and companies, like contracts. That's a biggie, especially for business, because it's all about agreements, making sure things are clear.
So contracts, that's basically the rule book for doing business.
Pretty much. And then there's the international side of things. That kicks in when, say, you're dealing with companies across borders. Suddenly you're navigating trade agreements and all sorts of international rules.
Got it. So we've got these categories, but then the materials also mention the philosophy of law.
Oh, yeah.
And I'm no expert, but why is that important? It sounds kind of like theoretical.
Well, the thing is, ideas about justice and fairness, they shape how laws are made and used.
I see.
And the materials mention some big names in legal philosophy. Austin, Hart, Savigny. All these guys had different views on what law is and what it should do.
So it's not just about knowing the rules, it's about understanding where they come from. Exactly. Like, some philosophers believe in natural law. Like, there are these universal morals that should be the basis of any law.
Okay.
Others say, no, it's all about legal positivism. Laws are what those in power say they are,
Interesting. So knowing those different perspectives helps you understand the whole system better.
Totally. And it can even help you analyze those laws. Are they fair? Just, you start to think more critically.
All right, so we've touched on types of law, even philosophy, but let's connect this to real life. Like, what's the point of all these laws?
Well, think of it this way. Law creates order. It's the framework that keeps society running smoothly. Without it, chaos.
Yeah, total mayhem.
Right. Law sets boundaries, makes sure everyone plays fair.
Makes sense. And it's not just about avoiding chaos, is it? The materials mention justice.
Oh yeah, justice is central to any legal system. And in Nigeria, it's about ensuring fairness for everyone. Fair trials, fair processes, the idea that everyone is equal under the law.
So it's not just having laws, but applying them fairly.
Exactly. That's what the rule of law is all about. It means no one is above the law, not even the government.
It's a level playing field.
Yeah.
Okay, what about human rights? Where do those fit in?
Fundamental human rights are protected by the Nigerian Constitution. Things like the right to life, freedom of speech, freedom of religion. They're crucial for a fair and just society.
They protect individuals, even from the government, right?
Exactly. But it's worth noting, no right is absolute. The Constitution allows for limitations, especially if it's about national security or public safety, things like that.
Right. So it's about finding a balance, protecting individual rights, while also considering the needs of the whole society.
That's it. So you've got law as a framework, justice as the goal, the rule of law keeping everything in check, and fundamental human rights as a safeguard. It all works together.
Got it. Okay, we've talked about what the law is, the big ideas behind it, but where does it all come from? What are the sources of Nigerian law?
It's like a recipe with different ingredients. The materials break it down into primary and secondary sources. Primary sources are the main ones.
Okay, so where do we start?
Well, we start with received English law. This is the law that came with British colonization. Stuff like common law, which is basically law that's developed from court decisions.
So judges making rulings, and that shapes the law.
Right. And there's equity, too, which is about fairness, filling in the gaps where common law is too rigid. And a lot of that stuck around even after Nigeria became independent.
Interesting. So it's like a legacy from the colonial period.
In a way, yeah. But then you have Nigerian legislation, laws passed by the Nigerian government. These are the big ones now. Kama, Soja, the Labor Act. You'll get to know them well.
Okay, so it's a mix of old and new.
Exactly. And then you've got judicial precedent, which is basically how judges interpret the law in specific cases. Their decisions set a precedent for future cases.
So each case adds another layer to the whole thing.
That's the idea. It keeps things consistent and predictable.
Yeah.
Then there are the secondary sources. Customary law that's based on traditions and customs, Right. And Islamic law, which is based on religious principles. But they can't conflict with existing legislation. That's the rule.
So it's a hierarchy.
Yeah, you could say that. And we can't forget about international law, especially now with globalization and all that. Treaties, conventions, those agreements influence Nigerian law too, particularly when it comes to business.
It's a lot to keep track of.
It is, but it's all connected, constantly evolving.
All right, so we've got this complex legal system, but you specifically want to understand business law. What does that cover exactly?
Business law. It's the rules of the game for businesses, basically. How they operate, how they deal with each other, with customers, with the government. It covers a lot of ground.
Okay. And I know your materials have a whole section on contracts. Let's talk about that.
Yeah, contracts are huge in business. They're everywhere. Buying, selling, hiring, getting loans, it all boils down to contracts.
All right, let's start there then. What is a contract, really? Can you give me an example, something simple?
Sure. Imagine walking into a coffee shop. You order a latte, you pay for it. Boom, that's a contract.
Wait, really? Just buying coffee?
Yep. You agreed on a price. They agreed to give you the latte. Offer, acceptance, consideration. The basic elements of a contract are all there. Even if it's not written down, it's still a legally binding agreement.
Okay, that's way more informal than I thought.
Right. But when it comes to business, things usually get a bit more formal. The materials define a contract as a legally enforceable agreement between two or more parties.
Okay, so there's got to be that meeting of the minds, like they both agree on what they're doing.
Exactly. And it's got to be enforceable, meaning the law recognizes it and can step in if someone doesn't fulfill their part of the deal.
Got it. So it's more than just a handshake.
Right. And there are all sorts of different types of contracts.
Like,
well, you've got informal and formal contracts. Informal contracts, sometimes called simple contracts, they don't have to follow any specific format. They can be spoken, written, or even just implied by how people are acting.
so even an email chain could be a contract.
It could. Then there are formal contracts. They got to be in writing, signed, all that jazz. Like if you're buying land, you'll probably need a deed. That's a formal contract.
Okay, so you got to know what kind of contract you're dealing with. That makes a difference.
Absolutely. And then there are different types based on how they're structured. Bilateral contracts, for example, both sides make promises to each other. I'll do this, you do that.
Give and take.
Exactly. Then there are unilateral contracts. One party makes a promise, the other party has to do something to make that promise come into effect. Think of those lost dog reward posters.
Oh, yeah.
Someone promises a reward, but no one's obligated to find the dog. But if they do, bam, the contract kicks in.
Gotcha. So action triggers the agreement.
Yep.
But not every agreement is a valid contract. Some are void, meaning they never really existed in the eyes of the law.
Like if you try to make a contract to do something illegal.
Exactly. That's automatically void. Then there are voidable contracts. They might look okay at first, but one party can back out if there was a problem with how the agreement was made.
So like someone tricked or pressured them.
Exactly. And then for a contract to be valid, period, it's got to have a few key elements.
Like what?
You need an offer, acceptance, consideration, contractual capacity, and the intention to create legal relations. It's like a checklist.
Okay, that's a lot to cover.
It is. But don't worry, we'll break it all down. We're just getting started.
Awesome. I'm already seeing how important this stuff is for business.
You're telling me. And in the next part of our deep dive, we'll really unpack those essential elements. We'll look at real-world examples, and you'll be surprised how often this stuff pops up in everyday life.
Can't wait. I'm ready to go deeper.
Let's do it. Welcome back. So last time, we talked about all sorts of contracts, right? And what makes a contract actually, legit.
Valid. Yeah.
Valid, that's the word. So are you ready to really get into the nitty-gritty of those essential contract elements?
Absolutely. Let's break them down, starting with offer.
Okay, offer. Sounds pretty basic, but I bet there's more to it than I think.
You'd be surprised. The materials define an offer as a clear proposal made with the intention to be bound by it.
So it can't be wishy-washy. It's got to be a real, this is what I'm offering kind of statement.
Exactly. And it has to be specific. The other party needs to know exactly what they're agreeing to.
Gotcha. So no vague promises or anything like that?
Right. And here's where it gets interesting. You have to distinguish a genuine offer from what's called an invitation to treat.
An invitation to what?
Treat. It's a legal term. Basically, think of those ads you see, or even just like products on a shelf with a price tag.
Okay.
Those are invitations to treat. They're tempting you, but they're not actually making a firm offer right then and there.
So like that amazing cake in the bakery window. That's not an offer to sell it to me immediately.
Not quite. It's more like they're saying, hey, we've got this. Come and make us an offer if you want it.
Oh, so it's like the first step.
Yeah, the customer makes the actual offer to buy.
Okay. And what if after I make an offer, I change my mind? Can I just, take it back?
You can revoke your offer, yes, but only before the other person accepts it.
Got it. So timing is key.
It is, and then there are counteroffers. Say you offer to buy something, but the seller says, nah, I want more. That original offer, gone.
So every time someone changes the terms, it's like a new offer.
Exactly. And even if there's no counteroffer, an offer can just expire. Maybe there was a time limit, or maybe it's been so long that it's just not reasonable anymore.
Makes sense. It's like milk going bad. Okay, so that's offer. What about acceptance? What makes an acceptance legit, legally speaking?
Well, the other party has to agree to the exact terms of the offer. No changes, no additions. If they try to change something, that's a counteroffer, and we're back to square one.
Okay, so it's got to be a perfect match.
Yep. And they have to actually communicate their acceptance. Can't just think it in their head.
Right, got to say it out loud or put it in writing or something.
Exactly. And there's this interesting thing called the posting rule.
The posting what?
Rule, basically, in some situations, like if you're accepting by mail, the acceptance is valid the moment you send the letter, not when the other person receives it.
Wait, seriously? So what if the letter gets lost?
Well, yeah, there are exceptions. Like if the offer specifically says the acceptance has to arrive by a certain date.
Okay, so there are loopholes. But it's interesting that just sending the acceptance can sometimes be enough.
Yep, that's the posting rule. All right, so we've got offer and acceptance. Now let's talk consideration.
Consideration. Now, this one always sounded a bit vague to me. Isn't it just about, being nice during a negotiation?
Not quite. In contract law, consideration means the value that each party brings to the table. It's the what's in it for me part of the deal.
Oh, so it's like an exchange.
Precisely. And it's got to be something of value, legally speaking. Think back to that coffee shop example. You gave money, they gave you the latte.
Right, right.
That's consideration.
Yeah.
No, it doesn't have to be perfectly equal in value, but there have to be something.
So if I buy a used car, my money doesn't have to precisely match what the car's worth.
Nope. As long as there's something of value exchanged, it counts. You might get a great deal, or you might pay a bit more. That's just part of the game.
So it's the fact that there's an exchange, not the exact amounts.
Exactly. And there are a few rules about consideration. One is that it has to come from the person receiving the promise. Like, I can't promise you something and then expect your friend to pay me for it.
Oh, that makes sense.
And another rule, consideration can't be for something that's already happened. I can't say, hey, I helped you move last month, so now you owe me dinner.
Ah, so no cashing in on past favors.
Nope. The consideration has to be part of the current agreement. And it's got to be something that the law recognizes as having value, even if it's a tiny amount. There's a famous case about a peppercorn being enough.
A peppercorn? Really?
Yeah, it's about the principle of exchange. Of course, in a business deal, you'd want more than a peppercorn. You want something worthwhile.
Right. Okay. Offer, acceptance, consideration. What's next?
Next up, contractual capacity. It's all about who can legally enter into a contract.
Okay, contractual capacity. I'm guessing most adults are good to go, right?
Generally, yes. But there are exceptions, like minors, people under 18. They usually can't enter into contracts. There are some exceptions, like for necessities, but the law tries to protect them.
That makes sense. They
Yeah.
might not fully understand what they're agreeing to.
Exactly. And people who are mentally incapacitated, they might lack capacity too. It all comes down to whether they can understand the agreement.
Right. It's about making sure everyone's on the same page mentally.
Yeah. And there's one more situation that affects capacity, but it's not about individuals, it's about companies.
Companies. How can a company lack capacity?
Well, they can enter into contracts, but they're limited by their own internal rules, like their memorandum and articles of association.
Oh, so those documents kind of define what they're allowed to do.
Exactly. And if a company tries to sign a contract that goes beyond those limits, it might not be valid.
Got it. So you got to check that they have the authority, basically.
Yep. Okay, so that's contractual capacity. Last but not least, we have intention to create legal relations.
Intention to create... Wait, hold on. Isn't that obvious? If you're signing a contract, you obviously intend for it to be legally binding, right?
In most business situations, yeah, that's the assumption. But things get a bit tricky with agreements between friends or family.
Okay.
Like, if I promise to help you move and you say you'll make me dinner, that's probably not a legally enforceable contract.
So I can't sue you if the dinner's terrible?
Probably not. Unless you explicitly said, hey, let's make this legally binding, I'm serious about that dinner.
Right. So with friends and family, it's more about trust and goodwill, not legal stuff.
Exactly. And sometimes it can even apply to certain agreements between bosses and employees, like a casual promise of a bonus. It might not be enforceable unless it's written down somewhere.
Interesting. So even in a work setting, you got to be careful about what you're actually agreeing to.
Absolutely. All right, that covers the 5 essential elements of a contract: offer, acceptance, consideration, contractual capacity, and intention to create legal relations.
Wow. We really went deep on that. But now I'm thinking, what happens when things go wrong? What if a contract is broken? Or something happens that makes it impossible to fulfill?
That's where we get into discharge, breach, and remedies.
Okay, now we're talking. Things are about to get interesting.
You bet. Because in the real world, contracts don't always go as planned. And that's where things can get messy, legally speaking.
Okay, so things are about to get real. We're talking what happens when contracts go wrong, right?
Right. Breaches, remedies, all the good stuff.
All the drama. But before we get to the, legal battles and all that, let's talk about what happens when a contract just ends naturally. The materials call this discharge of contract.
Yeah. Discharge basically means the parties are free from their obligations. It's like the contract has run its course.
Okay, like it reached the finish line. And I'm assuming the most common way is when both sides do what they promised.
Exactly. That's discharge by performance. The ideal scenario, everyone's happy.
Everyone wins. But let's be real, things don't always go that smoothly. What about when someone just doesn't do what they're supposed to?
That's a breach of contract, and there are a couple of types. First, you've got actual breach. That's when someone just straight up doesn't perform their part of the deal.
Okay, so they just don't deliver the goods or they don't pay up, something like that.
Exactly. And then there's anticipatory breach. That's when someone says or does something that shows they're not going to fulfill their obligation even though the deadline hasn't come yet.
Oh, so they basically give you a heads up that they're going to break the contract.
Yep. Like, say you hire a photographer for your wedding, and a week before, they call and say, sorry, can't make it.
Oof, yeah, that's rough. So what can you do in that situation?
Well, you have some options. You can accept the breach and sue them right away for damages.
So cut your losses and move on.
Right. Or you can wait and see if they actually follow through on the breach. It's a gamble.
A gamble, yeah. Okay, now let's talk about those situations where something totally unexpected happens, like a natural disaster or maybe a new law is passed, or even, a pandemic, stuff that no one could have foreseen.
That's where frustration comes in, is when something happens that makes the contract literally impossible to fulfill.
Okay, so it's not anyone's fault, it's just circumstances.
Right. The materials give examples like a fire destroying the goods that were supposed to be sold, or the government banning the type of work in the contract.
Wow, yeah, that makes sense. But what happens to the contract itself? Is it just over?
Under common law, yeah, it would be automatically terminated. But in Nigeria, there's a law that makes things a bit fairer. The Law Reform Frustrated Contracts Act.
Okay, what does that do?
Well, for one thing, it lets you get back any money you paid before the frustrating event. Like, if you paid a deposit for a service and then a new law made that service illegal, you could get your deposit back.
Oh, that's good. You shouldn't lose money because of something you couldn't control.
Exactly. And the act can even allow the court to award compensation for work that was already done before the contract was frustrated. So if one party had already started the work and incurred expenses, they might get some money back.
So it's about trying to make things fair even when the unexpected happens.
Exactly. All right, so let's move on to those situations where it's not an act of God or a new law that messes things up. It's just one of the parties breaking the agreement.
Right. Someone just decides not to fulfill their end of the bargain.
Yeah.
What happens then?
That's where remedies come into play. The law gives the non-breaching party some options to try to fix the situation, or at least be compensated for the harm.
Okay, so what are those options? What are the remedies?
One of the most common remedies is damages. That's basically money. The court orders the breaching party to pay the other party money to compensate for the loss.
So if someone doesn't deliver goods on time and you lose money because of that, they might have to pay you to cover that loss.
Yep. And the amount of money depends on the specifics of the situation and how much harm was caused.
It's about trying to put the injured party back in the position they would have been in if the contract had been fulfilled.
Exactly. And there are different types of damages. Sometimes it's just a small amount, like a symbolic gesture. That's called nominal damages.
So it's not really about the money, it's more about acknowledging that a wrong was done.
Right. But most of the time, the injured party is looking for substantial damages, real money to cover their actual losses.
Okay, makes sense. But what if money's not enough? What if the thing that was promised was, like, one of a kind, like a rare painting or something?
That's a good point. And that's where specific performance comes in. That's a remedy where the court actually orders the breaching party to do what they originally promised.
Wow, so they can force them to actually fulfill the contract.
In some cases, yes. It's not always possible, but if money can't really fix the situation, the court might order specific performance. Like for that rare painting example, they might force the seller to actually hand over the painting.
That's pretty powerful. But are there any limits to that?
Yeah, there are. It's not usually an option for contracts involving personal services. You can't force someone to work for you against their will, even if they broke a contract.
Right, that wouldn't be right. So specific performance is strong, but it's not a solution for everything.
Exactly. And then there are injunctions. That's where the court tells a party to either do something or stop doing something to prevent harm or further breach of contract.
So it's like a legal order to prevent things from getting worse.
Yep. Like if someone's about to break a contract by selling something they promised to you to someone else, the court could issue an injunction to stop them.
Okay, that's a good tool to have. But sometimes, maybe the best option is to just scrap the whole contract, right? Just call it off.
Sometimes, yeah, that's rescission. The contract is canceled, and everyone goes back to the way things were before the agreement.
Like hitting the rewind button.
Pretty much. And similar to that is repudiation. That's when the non-breaching party says, nope, I'm done with this contract because you broke it. They're rejecting it.
It's like taking a stand and saying, this isn't working anymore.
Exactly. And there are a couple more remedies. Restitution is about giving back any benefits that were already received under the contract, like returning money or property.
So if the contract's broken, at least you get back what you put in.
Right. And then there's rectification. That's a bit technical, but it's basically about fixing errors in the written contract so it matches what the parties actually intended.
So typos, misunderstandings, that kind of thing.
Exactly. So yeah, when a contract goes wrong, there are a lot of legal tools to try to fix it.
Wow, we covered a lot today. I feel like my brain is full of legal terms.
Well, you've got a good grasp of the basics now. You're going to ace that business law course.
I hope so. This was definitely a deep dive, and I feel way more prepared now. Thanks for walking me through all of it.
No problem. It's fascinating stuff, right? And it's all about making sure things are fair and everyone understands the rules of the game when it comes to business.
Absolutely. And on that note, thanks for joining us on the deep dive. We'll catch you next time for another deep dive into a new topic.
See you then.